loose ends like legacy planning and estate planning sometimes get overlooked. And most of the time it's really simple, and it's just small little details sometimes that totally catch us off guard and surprise us. And let's turn it this way a little bit more. So I want to welcome anyone join us online as well. And you can type your questions into the chat box there, and I'll answer them a little bit later. But what are some things you want me to make sure that I cover tonight? What are some things that are on your mind?
I guess my question is, what's the difference between estate planning and, say, a will?
Okay, good question. Difference between estate planning and a will. I'll make sure to talk about that. What else? And by the way, I'm not an attorney. I would never claim to be one, nor do I want to be one. But, we do have a background with a lot of these things because we deal with them so often.
Living trust.
Okay, living trust.
How taxation will affect your savings
Okay,
over time.
absolutely. Anything else coming to mind?
And insurance, is it whole life,
Mm-hmm.
where we can put money in a lot less.
Okay. How does life insurance fit in?
Yeah,
All right.
at our ages.
Yeah. Okay. All right. Well, we'll get started. If you think of any other questions, please feel free to stop me. This is interactive, so we can all just have a conversation. Okay. So I'm going to skip through the bio. We've been in business since 1997. We do full service financial planning. One of the big differentiators between us and other financial advisors is that most people are vendors. They sell specific products. If you go to a bank, they're going to sell you a bank product. If you have a stockbroker and that's all he does, he's going to sell you just stocks. If you deal with someone that works for an insurance company, and we know the big names of insurance carriers, they're going to sell you their proprietary insurance products. Well, the difference is we're financial planners, and we coordinate all those things. We're not limited to any one product, investment strategy, style. We can pull from all those different areas, and we're not limited as to what solutions we can provide. So instead of being a vendor, we're planners. We're kind of the quarterback that pulls it all together. So why don't more people have an estate plan? First of all, how would you guys define an estate plan? It sounds like a fancy term, right? Estate. Nice Southern word. Yeah.
For the rich.
For the rich, right? It sounds ritzy, doesn't it? My estate. Yeah. So, estate plan really is just how are we going to transition assets from one generation to the next? How are we going to avoid the state deciding what to do with my estate, right? And the key to doing that is to have a plan, right? So you have to have your own plan before you die, and that's the key. Most people don't have one because they're already dead, right? It's really important to have a plan before you pass away, to have all the things lined up, to have your account set up like you need to. Everything needs to be done, obviously, before you pass away, or it gets to be very complicated.
It has to be updated.
Yeah, and you have to update it. Things in your life change. If you get remarried, if something happens to anyone involved. Another fear is attorney costs. A lot of the solutions, I would say for 90+% of our clients, you can do it for less than $1,000 with an attorney. Now, it gets more complicated if you have to have certain types of trusts and appoint a trustee. There's more layers involved. Of course, it costs more for the legal documents and the administration of those types of estate plans. But for your average person who doesn't have tens of millions of dollars, it doesn't have to be super complicated. I'm the type of person, I want things as simple as they have to be to accomplish the goal. Why would you have it overkill if it's not necessary? So for many people, it's intimidating and confusing. Just the term estate planning is intimidating, right? So it doesn't have to be. I'm going to talk about some simple solutions that will solve most of your estate planning problems. And I'll be the first to admit, I don't know all the details and the legal ramifications of some trusts, but I know some of the basics about the ones that we see used most often. So we can talk about those. So here's some things that happen during estate planning. You want to try to avoid probate, right, at your death. Why would you want to avoid probate?
Going just through it, it's a long process.
Yeah, it's a
And
long
it's-
process.
And expensive.
It can be very expensive. Georgia doesn't have as high of a cost, but I know a lot of jurisdictions are raising their costs to probate. During the pandemic, they got backed up. I have a client in Texas that is going to be waiting several years to probate the will. They're so backed up in Dallas.
My daughter's 3 years now.
3 years? Wow, crazy.
I feel fortunate.
Healthcare should be part of your estate planning. You have to decide if you're incapacitated, who's going to make your healthcare decisions. And that's important, right? Certain people have different wishes with, if their life is prolonged, if they want to be resuscitated. That should all be handled during the estate planning process. And finally, taxation. How do we avoid taxes to the estate? So those are the top concerns that people have with estate
It's
plans.
minimizing taxation, not
Yeah, you want to
Or
not
avoiding.
maximize, yeah. Tax avoidance, by the way, is totally legal, but you can't evade. Tax evasion is illegal. Tax avoidance is used by every politician in the United States Senate. All right. So one of the more common ways, not so much in Georgia, but one common way of transferring assets is through a revocable living trust. Now, this isn't my go-to first, but in many, many states, revocable trusts are very popular. Florida is up to 9% of the cost of the total value of the assets it will cost you to probate. So trusts are used in many cases in the state of Florida because imagine, $9,000 of your $100,000 goes to pay the probate costs. Well, if you have a revocable living trust, it can be funded at your death, but you have to make sure those documents are set up ahead of time. Another reason for a revocable living trust would be if you have a beneficiary or an heir that you want to set parameters around how they receive the assets. A will alone can't do that. Okay? A will can't say, well, when Johnny turns 22, he can get 10% of the money. When he's 25, if he's graduated college, he can have more. There has to be a trustee and a trust in order to really accomplish that. A will, you can write that kind of stuff in the will, but it's not as enforceable legally. So that would be a reason to have a revocable living trust if you want to set up parameters around how the assets are received by the beneficiary. A last will and testament should be the bedrock of a lot of your estate planning. For most people, this and naming your beneficiaries will accomplish a lot of how assets are transferred. So a last will and testament, you obviously have to choose an executor. You want to choose a successor as well, or sometimes a co-executor. These aren't very expensive. There's more than one way to get them. I mean, online is fine in many cases unless it's complicated. We have attorneys, by the way, we can refer you to for these types of services, but almost everyone needs a will. A will is super important because most people have a home, right, that they're living in, and they may have money that's not in an IRA, things not covered in an account that lists the beneficiary. Well, without a will, it's going to go through probate, and the state is going to decide how assets are received. If you die in the state of Georgia and you're married, but your spouse who is still living has children, the money doesn't go automatically to the spouse. It's going to be split evenly between the spouse and the two children without a will. Did y'all know that? It doesn't go automatically. Now, other states are different than that, but in Georgia, it's not going to go to the to the spouse automatically. The state's going to split it up amongst even minor children. So that's something to consider. You definitely want to make sure that that's up to date. A lot of times people will have a will from 10 or 20 years ago, completely outdated. And that's more common than not having a will is having an out of date will. So make sure you update your will periodically. And y'all stop me with any questions if you have them. So one big downside of the probate process is the probate itself is a giant title search. You have to post in the legal newspaper of the area if someone passed away, and if anyone has any claims to assets, those are going to be coming after you at probate, right? Any creditors are going to come after some of the assets. And it also becomes a public situation, right? So the probate court, everything becomes public record at the probate court. So that's a downside. A lot of times people want to keep their private life private, but it's public record. Everything that's decided in the probate. Think about it. You go in there and listen. You can listen to how somebody's will is probated. Now, I don't know who would want to do that, but if you were someone prominent in the community, maybe a newspaper reporter, would go in there and see how the will was probated, right? So you can avoid that by trying to avoid probate. If you have things properly done in your estate plan, you can completely avoid probate. I think that's a good goal. People should not want to have to go into a probate court to have their assets split out. So another thing is interested parties can come and contest the will during probate if it's probated. And they can even contest the will regardless, right? They can say, that's not right. The person wasn't in the right faculties whenever they wrote this will. 10 years ago, they told me I was getting the money. We've all heard of those terrible stories. And that's another good point. People that you don't want to see families fighting over assets. It's a sad thing. And if you've made it super clear and have all your estate planning done, you're going to avoid that situation many times. But people that just say, let them fight it out, sometimes that'll happen. So you can also avoid fees as well on the probate cost by having a simple will. So we mentioned before the revocable living trust. It allows assets to transfer outside of probate. So when you have a trust, you have to have a trustee. One downside to a trust is you can't just throw an IRA or a Roth IRA into a trust because they're taxed before they go into the trust. So you don't want your IRAs just to become taxable automatically when they go into the trust. So non-qualified assets can easily be put into a trust, home, property, those types of things. What was that? Cars, all those things can be put into a trust. You just need to name a trustee and then the beneficiary. And you can stipulate in those trust documents exactly how you want it done. You also have to name how it's going to be funded. A lot of people have trusts that never get funded at their death. A lot of good that does, right? So if you have a trust that's funded at your death, the transferee or the beneficiaries on those accounts need to list the trust to get the assets at death. Otherwise, completely waste of time, money, and effort. The trust has to be funded to work. I've seen it more than once where people had a trust and never funded it.
Now, on a trust like that, do you need to get a tax ID also?
Typically they're going to be taxed differently. They do have different tax rates too. You get to the higher tax brackets at lower amounts coming out of a trust. So taxation always has to be thought about with your estate planning. So if you work with an attorney and you decide, I really need a trust, you need to ask, well, how will this be taxed coming out of the trust? Because if you're going to pay twice as much taxes, you may choose an alternate route, right? They're not going to just volunteer that information. Probably they're used to doing it their way, but you need to understand how the taxes work on the trusts when you do it. So one very, very important thing when you're doing estate planning is how to plan for health care. Who's going to make the decisions for you if you can't? And this is one of the foundational types of documents you're going to need. In Georgia, it's now called the Advanced Healthcare Directive. Georgia Advanced Directive for Healthcare. This is going to name an agent authorized to make healthcare decisions on your behalf. It's also going to have a HIPAA release form built into it, so information can be shared with them if you're incapacitated. And it'll allow you to record this and also stipulates if you want to be resuscitated, under what circumstances. I had a personal experience with this about 15 years ago. My mom was an only child, and my grandmother had a do not resuscitate order, but my mom had a power of attorney in addition to the Advanced Directive for Healthcare. So my grandmother was in Cochrane, and they couldn't treat her for the way she needed to be treated. She needed to be moved to Macon. Well, the ambulance would not transport her if she had to do not resuscitate. They said, we're not moving her from here with that on file. And so my mom, and I helped her decide, we overrode the do not resuscitate just for the ambulance ride. And then it went back in force when she got to make it. My grandma, she ended up living another year or two after that. So having these estate, and my grandparents, her parents did a great job of estate planning. They lined things up properly. So this is a crucial document. Everyone needs an advance directive for healthcare. And that will stipulate all the things we just talked about. Any questions on that? So that and the will are things that a trust is maybe. These are not maybes. You need this. There's no reason not to have it. Another one is there's a couple different ways that you can list a decision maker. You can use a durable power of attorney that would help make financial decisions. An advance directive for healthcare is not going to give someone implicitly the ability to write checks out of your account. A durable power of attorney is going to be used for that. You can use a living trust to direct future asset transfers as well. But, excuse me, the durable power of attorney is for while you're alive. You need to select probably someone that's financially capable to make financial decisions on your behalf. But the durable financial power of attorney, I would say, is a crucial document to have. And that lists someone. You want to list a secondary person too, in case you and your spouse, most of the time you're going to list your spouse until they're not able to do that. But you may want to list someone else as a backup for all these, just in case. If you're getting it done anyway, why not go ahead and make the one extra step of having a backup, right? So they're going to be able to make financial decisions on your behalf by executing the durable financial power of attorney. And this is something we use and see used in our practice, right? So a client may become incapacitated and a child or a sister may sign on their behalf. He has power of attorney acting in the best interest of the person that they're doing it for. So the durable financial power of attorney. Any questions on that particular topic? For us to enact one, you would just need to bring us a copy of your financial power of attorney. And then as soon as we have it on file, and you can sign on that person's behalf. We do have it reviewed, of course, just to protect everyone. Did you have a question?
I was just gonna ask, that has to be initiated by a physician, right? That they
The
are,
durable financial power
that
of
they
attorney?
are financially, that they are incompetent,
Yeah, yeah. And this, if they're not able to act on their behalf,
like Alzheimer's or something.
yeah, generally you would have a physician enact it.
Mhm.
Yeah. And sometimes if there's a trust and you list multiple trustees, it may say if 50% of the trustees say that I'm incapacitated, then you can enact the trust, even without a doctor's order, So sometimes it's smart to have multiple people and say it by majority vote. If they all say I've lost my mind, then they can take over. Yeah. All right, so this is a big one. Taxation and fees. Will there be taxes on my estate? Who knows the answer to that? Yeah, almost always. But the estate tax is very high right now. It's been as low as $1 million. If you had more than $1 million, estate tax, it would be taxed at the federal level. If you had over $1 million. Right now, if you're married, it's $23 million. 11,530,000, something like that each. You can get a spousal exemption. So this will not affect many people, but they're always wanting to lower that. Most people in government do not like the idea of being able to pass wealth from one generation to the next. They're only able to do that. They don't want us to be able to, right?
So you're saying there's no taxes on the estate unless it's over the 23 million for a married couple?
Yeah, there's no federal estate tax on it. There's taxes,
Yes.
not the estate tax. So you don't need to be worried about estate taxes right now. They're not low enough. But obviously, there's going to be taxes on IRAs, on real estate. And there's certain assets that are much more tax efficient to transfer wealth from one generation to the next. Who knows the least efficient way to transfer wealth? Anybody?
Okay.
That's pretty efficient. IRAs. IRAs are the least efficient way to transfer wealth because now there's new rules in place, which I'm going to touch on in a second, which really restrict how those assets are allowed to be handed out in stipulated time period. The most tax efficient way is Roth IRAs and tax-free death benefits. Also non-qualified stocks. So if you bought Coca-Cola at $10 a share and have had it for 50 years, when you pass away, it doesn't matter if it's $1,000 a share, the stock is transferred based on the price it was on the date of your death. So all that growth would be tax-free to the next generation. So those are 3 tax efficient ways to transfer wealth. Tax-free life insurance. He had a question about overfunding a life policy. When you're younger, 30s, 40s, 50s, sometimes early 60s, you can overfund one. The older you get, the higher the cost of insurance. The way to overfund a policy is you buy the minimum death benefit you have to, and you put the maximum cash into it the IRS will allow. And then when you pass away, there's 2 ways you can do it. You can draw tax-free off the death benefit while you're alive. And if there's money left, that's tax-free to your heirs and to the estate. So that's a very tax-efficient way to transfer assets if you're able to get it and get underwritten for it. You have to be in good health. Roth IRAs, all tax-free as well, but those still have to be liquidated in a certain time period after your death. So that's how the taxes work for most people. The other really bad thing is if you have a 401k and you leave the assets in the 401k, they don't even allow you to stretch it out. They have to just take the lump sum out of a 401. So those are really, really tax inefficient. A self-directed IRA, you can do anything you want to with them. So the Secure Act passed in December of 2019. It changed several things, including how certain assets from your estate are taxed. First of all, required minimum distribution age moved up to age 72. So you don't have to take money out of IRAs mandatorily until you're 72 now. Now, here's the bad part. If you're a non-spouse and you inherit an IRA, now you have 10 years to liquidate it if you took possession of it after that date. So 10-year period, you've got to liquidate the IRA. So let's say your children are successful and they inherit $500,000. Well, they have $500,000 that they owe taxes on, and they can take it all out at the end of the 10th year, but more importantly, or more intelligently, they would split it up over that 10-year period and take $50,000 a year out over that 10-year period. You used to stretch it over their lifetime, and that was much more tax efficient. But the IRS is hungry for assets. They need more tax revenue. So they tweak all these little things, and a lot of people don't even know about it, and they end up getting a lot more tax revenue. This is something that's still allowed under the Secure Act. Is qualified charitable donations and distributions are still allowed to minimize taxes. So if you're 72 and you're sending out a required minimum or taking a required minimum distribution, you can direct it straight to the charity. You can also do that the year that you turn 70 and a half. You don't have to wait to age 72 to do the qualified charitable donation. All right, so a living trust encompasses a lot of different things. It's like a trust that can dictate how your health care is determined, also how assets are handled after your death. But they'll have a trust declaration, durable power of attorney. They kind of handle a lot of different things. Living trusts are pretty popular to use. So you may want to ask somebody, is a living trust appropriate for me? It'll have something else called a pour over will, which means that after your death, the rest of the assets that weren't a part of the trust would pour over into the trust automatically as well. But again, you're not going to put IRA assets into these. You're going to put non-qualified assets, real estate, stocks, cars, whatever, into them, not IRA qualified assets.
And then they still have costs because somebody has to maintain it.
Yeah, that's a very good point. If you have a trust and it has investments in it, for example, not only are you going to pay a trustee like a bank, a financial advisor can't be a trustee. It's against the rules. You can't be a trustee and the financial fiduciary. You have to have 2 different ones. So that means you got to pay 2 different people. So like Truist Bank here locally, they'll act as trustee. But then you have to have someone else typically advise how the assets are done too. The trustee's going to charge 1 to 2% of assets annually to manage the trust. Then you got to pay a financial person. So they're not inexpensive. You have to have a really good reason to do a trust to hold assets.
To make it worthwhile.
Enough assets to make it worthwhile and a reason to do it, right? Like someone you need to make sure doesn't get all the money at once, that kind of thing. Or a disabled child, very good reason. So here's some mistakes to consider. This is the biggest one. This isn't a fun topic, right? It's one of those things we would all put on the back burner very easily. So you want to make sure that you don't procrastinate. A lot of these things will affect you and your loved ones dramatically if they're not in place. It reminds me, like if you're a young person and you're newly married and you've got kids and you don't have any term life insurance, that's a terrible idea, right? Because you could very easily and inexpensively protect your family if something happened to you, but you just didn't get around to it, right? Same thing with this. You need to get it in place so you don't have those negative things happen to you. You need the durable power of attorney, the advance directive for health care while you're alive, right? In case something were to happen. Outdated plans, which I mentioned earlier, you need to update things. Beneficiaries, when I do a review, I usually try to remember to ask, have any of your beneficiaries changed? You'd be surprised how often people will change their beneficiaries for a variety of different reasons. But make sure your beneficiaries are up to date. Let me also mention, if you have a bank account anywhere, you need to put a TOD, a transfer on death file on the account. And that avoids probate. A person at your death can walk in there with a death certificate, and if they're listed as the TOD, the transferee that gets it on your death, they hand them the money, and it's over.
What about if you have them listed as beneficiary
On an IRA?
on a bank account?
Yeah, that's the same thing. So TOD, transfer on death, if they call it, whatever they call it at your bank. Some of them call it POD, payable on death. Yes, ma'am?
Well, if you have the power of attorney, that's only in the case of your incapacity.
And you have to be alive to use the power of attorney.
Right, okay.
Yeah.
So that
Mhm.
would make a difference.
Yeah, if someone has passed away, if you don't have a POD or a TOD on that bank account, it has to be probated along with any other assets that aren't named. I like it better if you don't even have to worry about the will in that situation. Any beneficiaries of life insurance, annuities, IRAs, or brokerage accounts or bank accounts that have a TOD on it, it transfers automatically to the people listed with a death certificate. And that's way easier than having to go through probate and all those things. You want to do as much as you can with as little resources as possible, right? And those are very efficient, easy ways to do it.
Okay, if you have a bank account and you're a joint bank account,
Mm-hmm.
but one of us were to pass away,
Mhm.
the other one still has access to
Yes.
those funds, nothing gets frozen, right?
That's correct.
Now, if we were both
You want them
killed,
jointly. You can still put a TOD on a joint account, though. In case something both of you happen. You can put a TOD on a joint account. And you should. You should have it on a joint account.
Yeah, that helped me out a bunch with the death of my mother by being on beneficiary.
Yes.
but we did a will, and I'm assuming we said for checking accounts.
You can do that. But what I'm saying is if you have the TOD, forget about the will. You have to go through probate to get it in. With a transferee listed on the account or a beneficiary, it's immediate. You don't have to probate it or wait. There's no waiting period.
But if there are, okay, let's say, there's several people that would be beneficiaries of us.
Yeah.
But so to transfer it, would you say to transfer it to the executor of the
I would.
estate?
I would break it out on there by percentage. That's
Oh,
so who would get
okay.
what?
Okay, okay.
That was my question.
Yeah, it's way easier than waiting on the probate court and paying a fee to the probate court. If you already know what percentage people are going to get, just set up all your accounts that you possibly can to get that and avoid everything being probated you possibly can. So make sure you update your beneficiaries, know the new estate tax laws. From time to time, any serious things change, we're going to be telling you, because we try to stay up to date with this. So a lot of times, if you have a trust, I've seen it multiple times where trusts aren't funded. So if you have a trust, make sure, ILETs used to be really popular, life insurance trusts, or that are trusts that are funded with a life insurance policy. Make sure that beneficiary on that life policy names the trust as the beneficiary or it's irrelevant. The trust has to be funded to work. So you need a plan that's specific, right? LegalZoom.com may be fine for a will, but if you need some serious advice, I would sit down with an attorney, and say, well, my situation's different because of these reasons. So you don't want a cookie cutter solution. But again, a lot of times these things can be done with the basics. So unless you have a really unusual situation, you shouldn't need fancy trusts and things like that. Sometimes they just overcomplicate things. Not having a durable power of attorney, very important, because you need someone to manage your assets. Now, if you ever have all your assets jointly with your spouse, that's fine. But I think it's smart to have a backup, right? Have a durable power of attorney with someone backing you up in case both of you are incapacitated. It's very easy to do. If you're already sitting down to do the document, list some backups. Beneficiary designations. I've seen this. This is the worst thing. Someone gets divorced, and they listed, in fact, this happened within the last year. Someone had been married for 5 or 10 years, and then they're new to their new spouse, but they had forgotten on an old employer plan to change the beneficiary from that ex-spouse, and it went to the ex-spouse. There's nothing a court can do about it. That is a legal binding document. If they're listed as the beneficiary on there, it's going to them, period. It doesn't matter who contests it.
I will say this, the company I work for, they make us do it every year.
Yeah, you want to make sure you do
We
that.
have to
But if you don't work there anymore, it's a little different.
Yeah.
Because, they're not in touch with you, and that's what happened in this case. He'd forgotten all about that. Yeah. So you want to make sure you update your beneficiaries, have secondary and contingent beneficiaries. If you have life insurance, make sure it's set up properly too. Never list the estate as the beneficiary on a life policy, right? You want to avoid assets going into your estate if you can. You want it to go directly to the people who get it, so it's tax-free to them in every way. Okay, attempting to plan alone, right? So a lot of times people will try to title assets in joint names with a friend to generate a taxable gift or add children to bank accounts. All that stuff's fine, but you want to make sure you understand the ramifications of it, right? So I'll tell you a ramification to this one. If you own a bank account jointly with a child, and then you have to go into an assisted living or a Medicaid facility, nursing home, there's a rule that you can't have more than $30,000 worth of assets. And if that child was added to that bank account within the last 5 years, they have to pay back. It doesn't matter who spent the money because you own it jointly. They'll have to pony up all the money spent out of that account in the last 5 years. I've seen it happen. Don't just add someone arbitrarily to a joint bank account. They're going to look back for 5 years. They do this because it's one of the biggest budget items for the state is paying for nursing homes, right? So you can't just add yourself on there and say, well, that takes care of that. Because if they end up needing to go to the nursing home, they're going to look back and see when you were added to the account. And I had a client that had to pay $3,000 back, even though the mom owed her $3,000. It was done improperly, so the child had to pay $3,000 back to the mom so the state could take it. Yeah. You gotta look at that very carefully.
Because that was like on my mother's account for like 15 years.
Yeah. Do we have any other questions? Are there any online questions?
Mhm.
So we read them off to me?
Bullet wants to know, hello, my mother-in-law thinks her advanced care directive is written into her irrevocable trust. Is this ever the case to your knowledge? Aren't they separate documents?
It could be. It just depends on how the trust is written. You'd need to ask an attorney that question so they could read the trust and see how it was stipulated. I wouldn't dare guess that. Let's see.
Rhonda wants to know about capital gains taxes.
Okay, so capital gains, if you inherit an asset, so capital gains while you're alive depends on your income tax bracket. So if you are a married couple and you make less than $40,000, you're going to pay 0 capital gains. And when you get up to $80,000, you start paying 15%. And if you pass away, capital gain is taxed based on, well, number one, what type of asset it was. If it was a stock, you inherit it at the price of the date of death. So Just depends on some of the other details on that one. What's the last question?
It was still Rhonda. She wants to know, would having the parent add them joint on account work?
I would not do that. I think I just covered that. If you add them jointly on the account, you become liable for some issues. Like if they needed nursing home care, you've added your name to that account, and if money comes in and out, it doesn't matter if it was really your parents' money or your money. They're going to assume that you owe the money. So, any other questions? So that's a little bit about estate planning. Hopefully it was helpful, but we can refer you to some attorneys, and we have different ones that we've used for different reasons. We kind of specialize in different areas. So if you want to let us know. If you have any questions, we can get you one. Yes, sir.
What happens, okay, so you've got a will,
Mm-hmm.
and typically in the past, and we've got a current will, or fairly current. And, you know, when you return it, after you've signed everything, return it to the attorney, they file it with the probate court.
They should.
What happens to that? I mean, if you don't want to go through probate, what happens to that will? Does it ever get read? Does it ever get drawn out of?
I don't think they're just going to go pull it out and read it automatically. To answer your question, I don't know for sure, but it would surprise me if no one brings a matter before the probate court. It would surprise me if they would go through the trouble, as busy as they are, to go and pull all the documents for anyone that ever filed them. Somebody's probably going to have to bring a matter before the court for them to read it, but I could be wrong. I don't know for sure on that. Yeah, you definitely, if you get a new one, you want to make sure that a new one is recorded and the old one is taken out. It can be confusing if there's multiple copies that date it differently.
If you do a new will and you put in it, and stipulate that this replaces all prior wills.
Yeah, definitely want to do that.
That would take.
I think so. I mean, I'm not 100% sure that's all that's
Okay.
required, but I've heard that wording before.
Yeah,
You know, I've seen it. So again, legal
but
question.
an attorney that specializes in this area. would
Yes.
know that.
What you
Yeah.
said, I have heard before, and it makes
Okay.
sense to me, but I can't guarantee make any claims.
I know when we just went through with my mother, they made like 4 different copies to send to the probate.
Yeah, it's good to do that. It's good to have a copy too in your house. Give anyone that's going to be, well, your spouse. I wouldn't give it to my beneficiaries yet until someone passed away. Otherwise, you might meet an early demise. All right. Well, thanks everybody for coming. And if you ever have any questions about this or want to review your beneficiaries with us, just let us know. And we can certainly update those for you. But thanks for being here. And I think we have some Chick-fil-A for you. Have a good night.